So for the purposes of making the structure of the webinar a little bit easier, we've taken the agreements and we split them into two very broad categories, being those of internal agreements and then external agreements. So starting off with internal agreements. So to give you an idea, an internal agreement, as the name would suggest, means any agreements that we have internally in the company and really doesn't affect outside or third parties. So first internal agreement, I think this is the most obvious one, is your employment agreement. So I really don't think there's very many people on earth that don't know what an employment agreement is, but naturally it's the agreement between your company and your employees. So employment agreements, although they sound very straightforward, very one-toned, they're not so simple. They're not so straightforward if you really actually take a little bit of time and make sure that you've got the right things in place. There are two very broad categories of employment agreements that we deal with in our companies, and those are fixed-term employment agreements and permanent employment agreements. So for the majority of your employment agreements, will be the permanent employee agreements. Obviously, those are employees that you employ for a specific purpose or for a specific role. And when you employ them, you've got no timeline on it. You don't have, um, sorry, guys, I just had to take control of the presentation. There's no specific timeline on it. So in other words, let's say you employ a receptionist. The receptionist isn't going to be there only for 3 or 4 months. It's someone who's going to permanently be employed by the company and who's going to stay with the company for the foreseeable future. A fixed term employment contract is naturally also, as the name would imply, a little bit of the opposite. It's someone who's employed for a fixed term and usually for a very specific goal or for a very specific project, for example. Both of the contracts, both of the employment agreements are governed by the BCEA, the Basic Conditions of Employment Act, as well as the Labor Relations Act. Just as a point of interest, even if you don't have employment agreements in place in writing, these acts still apply. It's not something that you can contract out of. Also, the conditions that are set forth in the BCEA do still apply, even if you don't make provision for them in your agreements. So very important to note, you cannot, although you have contractual freedom, you cannot just go and put any clauses into your agreements, especially when they contradict the acts that are in place. One has to still stick to the legislation, and if you do not, then the legislation will suffice. So permanent employment contract, I think I've gone through this, but just let's go through the slide as well. So when a person is employed as in a permanent position, it's extremely important that such employment be reduced to writing, signed by both parties. Purpose of the employment contract is to set forth the rights of both the employer and the employee. Following requirements for a valid employment agreement are in place, must be reduced to writing and must be signed by both parties, and it must contain some of the following terms. This is, like I said, these are in terms of the Act. It has to have the commencement date, the place of employment, the remuneration of your employee, the hours of work, the employee's duties, all sorts of leave, and then also the termination of the employment. Like I said, yes, it has to be in writing, but it's not a requirement by law that it has to be in writing. Obviously, that's just to safeguard both parties and to make sure that there's some sort of surety, um, definiteness if something happens in terms of the agreement, so that you can fall back on the written agreement rather than trying to say, oh, but he said this, she said this. That's never a good thing when we look at contracts, is verbal agreements and trying to prove something that someone said way down the line. Then your fixed term employment contract. So in terms of section 198B of the Labor Relations Act, an employee may be appointed for a fixed term. The following requirements are, however, in place for a valid fixed term employment. It must be reduced to writing, it must be signed by both parties. The period of employment for a fixed must be in there, and it must be for a fixed period. So the agreement has to state this, that the employment agreement is only in place for, let's say, 3 months or 6 months or whatever the case may be, but it has to be specified. Then it has to specify the reasons for the employment of the fixed period, remuneration, hours of work, duties, the sick leave, and termination of the employment also has to be specified in the agreement. Then a third and Also, another type of employment, if I can put it that way, agreement is the agreement between the company and an independent contractor. So an independent contractor is a person that is not a permanent employee of the company, however, renders a specific service to the company. So characteristics of an independent contractor are as follows. The agreement must be in writing. It must be signed by both parties. The core agreement is for the contractor to render specific services to the company for payment. The contractor will invoice the employee or the employer, sorry, on a monthly basis, and the employer will pay such invoices on a monthly basis. The contractor, and this is important because this is what differentiates a fixed term agreement from an independent contractor, is an independent contractor actually uses their own tools of the trade. So they have their own computer. If they are painters, they bring their own paintbrushes and paint, etc. Contractor is not entitled to any employment benefits such as leave, etc. And the contractor is liable for his own tax liability. So the company doesn't pay as you earn on their behalf. The the payment of the tax as well as the tax submissions on all of those are done by the contractor, him or herself. And then I just made a note. You'll see later on in the presentation, we'll get to an SLA, which is a service level agreement. So an independent contractor sounds a lot like a service level agreement, but the difference between the two is an independent contractor is usually a person that renders a service, whereas an SLA is usually between the two companies, where it's a company rendering a service on behalf of your company. Okay, and then a top tip in terms of employment agreements are that you can actually amend your employment agreement from time to time. So if you have now appointed a secretary to come and sit, or let's say you've appointed a receptionist to come sit in your reception and answer the phones, but you see this person is actually very bright and you'd like to have them do some other admin duties and give them a little bit of a raise, obviously you can do that. But the good idea, or a good idea in general, would be to make sure that everything is in writing. So instead of going and doing a new employment agreement, you can actually amend your current agreement by adding an addendum and making both parties sign it and making sure you place that addendum together with the agreement in your filing. Addendums, obviously, or any amendments to the employment agreement must be accepted and agreed upon between both parties. So you can't go and one-sidedly change the agreement, let's say, to make the money less or to make the hours more. It has to be agreed between the parties. If it's not, then it could actually be something that can be referred to the CCMA. So don't go there. Make sure if you do any amendments to the agreement that both parties have agreed, put it in writing, add it to the agreement that is already in place. Okay, so that concludes our section on employment agreements. So the second agreement in terms of internal agreements is your Memorandum of Incorporation. So I don't think there's a lot of people that haven't heard the word or the words Memorandum of Incorporation and don't know about the contract. I don't, however, think there are a lot of companies that actually have taken the time to go and draft their Memorandum of Incorporation formally and have a Memorandum of Incorporation that actually reflects the company, reflects the internals of the company. What happens is if one registers a company with the CIPC, usually people will use a consultant or an accountant or whoever the case may be to go and register their company on their behalf. And what happens is the memorandum of incorporation most of the time is a standard set. It's a standard memorandum of incorporation that's not specific to your business. So yes and no, it could be a good thing, it could not be a good thing, but it's always a good idea to make sure your memorandum of incorporation reflects what your business is and what your business wants to achieve. So, what is a memorandum of incorporation? It is basically the constitution of a company. So, it's the ground rules. It's a set of it's an agreement that sets out how my company wants to run, what is the company, how it's going to be incorporated, all of those basic things, which is why it's important to have one, obviously. So, what are common clauses of a memorandum of incorporation? So, one, it dictates the incorporation of the company or the nature of the entity. So, is it a company? Is it a closed corporation? Is it a trust? Is it a partnership? Whatever the case may be, that has to be determined by the memorandum, or at least has to be canvassed by the memorandum of incorporation. Then it sets out what is the business and what is the objects of the company. So, in other words, if I'm registering a business that's an accounting firm, your memorandum of incorporation will state the very same thing, to say this is a firm that sets out to render accounting services. Whereas an attorney's firm obviously will say this is a company that sets out to render legal services. Then the memorandum of incorporation also canvasses the membership or the shareholding or directorship of the company. It does not necessarily have to say who will be the members and the shareholders or the directors, but it may say what shares, how many shares, all of those things. But obviously, if at a point in time when you're drafting your memorandum of incorporation, your directors and your shareholders and all of those have been appointed, those details can also be included in there. So the membership, shareholding, directorship clauses would be how to appoint and remove such shareholders, directors, or members. What will their powers and their operations be? What is required of them? And the liability of those people. Um, just as a sidebar, there are so many agreements that we can actually canvas. Obviously, we can only canvas so many in a webinar that we have a limited amount of time in. But just to give you an idea, when we speak about the powers and the operations of directors and members and all of those things, there would be a second agreement which directs, or your directors agreements, which say is like much like an employment agreement, which will set out what the directors have to do and how they are being held to account, and directors meetings and all such things. Just to give you an idea, the MOI doesn't have to be so complete and so detailed as to put all of these details in. It's more of a high level agreement that goes into the operation of the company, but not so much into the operation as in day to day and directorships and so on. Then it also sets out what the rights and obligations of the members or directors or shareholders are. It sets out operation of the company, so meetings and resolutions, etc. It sets out limitations on the company, and then also it has quite a substantial amount of accounting arrangement usually. Things such as how often does one have to do an audit? Is an audit a requirement? Obviously, in terms of the law, certain companies are obliged to audit. The majority of small companies are not obliged to audit. If the company, however, decides that they want to do a yearly or an annual audit, then obviously this will be included in the MOI. This will be a specific requirement for your specific company. So all of these things are canvassed in the MOI. Top tip, the MOI will be the guiding agreement in terms of in the event of a deadlock of shareholders and directors. So just again, on a sidebar, there will be a shareholders agreement in place, most likely. There will be a directors agreement in place, most likely. And then there's the MOI. So like I said, the MOI is the foundational documents of your company. So this will be the first place to go and look for any sorts of, how do I figure this out? How do we settle this dispute type of questions? Then, as I made a mention of, we've got our further agreement, which is the shareholding agreement. So a shareholder of a company, in very, very layman's and simple terms, can be described as this is the owner of the company. This is the person who has shares of the company as an asset in their personal estate. It's not the directors. There's a massive difference between who's a director of a company and who's a shareholder of a company. A shareholder doesn't really have to work in the company. I mean, you can own shares in Vodacom and never set foot in Vodacom. It's merely you have ownership of shares in the company, which naturally one would hope would lead to some sort of payment of dividends at some point in time. So it would be, in other words, it's an asset in your personal estate. A shareholders agreement is an agreement among the company's shareholders that describes how the company should be operated and outlines the shareholders' rights and obligations. So there's definitely an overflow between the shareholders agreement, the MOI, and the directors agreements. That is one thing that one has to decide, which is also why it is important for these three documents to be drafted at the same time, to make sure that your MOI reflects what the shareholders, or your shareholders agreement reflects what the MOI dictates, and then obviously all ancillary agreements follow. We don't want the agreements to clash. We don't want there to be some clauses in the one agreement that completely overrides another agreement. They have to be drafted and signed and everything hand in hand. The shareholders agreement is intended to make sure that the shareholders are treated fairly and that their rights are protected. I think that goes without saying. The usual clauses included in the shareholders agreement would be the value and the amount of shares. As you probably know, a company can decide to issue 100 shares, 1,000 shares, 1,000,000 shares. It really does depend on the company itself and what the value of each of those shares are at in the instance of the company also is something that can be determined by the shareholders of the company. Then the shareholders agreement will reflect the ownership of the shares. Naturally, with bigger companies such as Vodacoms and so on, obviously those agreements won't change every time a share transfers, but it should reflect at least what happens in terms of ownership and how that should be reflected. Is it only in terms of a certificate of shareholding, or is it something that has to be amended in the agreement? All of these things can be contained in the shareholders agreement as well. Then the appointments of directors and the operation of the company. So, like I said, the shareholders of the are in effect the owners of the company. They sit with the company's shares as an asset. The shareholders don't run the company, however. They're not the person on the floor. Sometimes it does overlap, obviously, especially with smaller companies. But it isn't an absolute requirement that the shareholder has to actually be appointed by the company or employed by the company or that they actually have any work in the company. So, what the shareholders will do to make sure that their asset is protected is they have to, in their shareholders agreement, make a decision regarding the appointment of directors and the operation of the company. So the shareholders usually, let's say there are, for example, four shareholders in a company, usually the shareholders agreement will state something in the lines of each shareholder can appoint one director and that there will be one independent director which will be recruited and appointed by the company or by the other directors as a sort of an independent director that doesn't have any relation or any specific alliances with any specific shareholder. But it is important to note that as a shareholder, you don't necessarily have any involvement in the day-to-day operations of the company, and you don't actually have any employment duties also in terms of the company. Then the meetings of the shareholders will also be accounted for in the agreement. This is also entirely up to the shareholders themselves, bearing in mind there must be a base minimum. So shareholders do need to meet from time to time, obviously, to discuss the operations of the company and so forth, but it doesn't have to be a month-on-month thing. And then, importantly, the shareholders agreement must be binding on the directors. I think this goes without saying, but just to give you a little bit of a food for thought in this regard, if you are, as a shareholder, an owner of a piece of the pie, as one would say, the company is an asset, but it's being run badly by the directors, and the asset is diminishing. Obviously, um, you would want your agreement to be binding on the directors because you need to still be in some way or form in charge of the directors. If you're not, and the directors run the company at will, and it's to the detriment of the shareholders, and you've got no rights to interfere or to try and force the directors to change their ways or to stop or to fire a director or so on, then it could lead to disastrous effects for your shareholding and for the value of that asset. Then the next internal, it's not so much an agreement as it is a document, is the POPI manual. So I don't think there are very many people that haven't heard of POPI, especially in the last 2 years. It's really been at the forefront of news of everything that we think about of fear-inducing comas. So POPI is short for the Protection of Personal Information Act. So I think the name really does dictate what it is. POPI places a very stringent requirements on companies regarding the protection of personal information. The manual must direct the company how personal information must be obtained in the normal course and how that information should be stored and processed. The physical manual must be in existence and must be available for inspection. That's obviously if some sort of authority pitches up at your door, you have to be able to produce it. To give you a very broad idea, obviously in our businesses, yes, we work with clients. So yes, we have information that we are not entitled and just at liberty to just share and do with as we like. As a very basic example, the fact that your cell phone rings at any given moment and it's a company that's trying to sell some sort of insurance or whatever the case may be to you means that there's been a breach in the personal information that you've given to another company. So if you go to the bank, you apply for a home loan, all sorts of personal information, a big slew of personal information, in fact, is given to the bank, obviously for them to perform their due diligence and to perform with their FICA requirements, etc. That information, however, is not the bank's information, it remains your information. The bank is not at liberty to just give that information to whomever desires. and it's most certainly not at liberty to sell that information. And this is what Poppy seeks to protect, is your personal information given to another entity in the purpose of a specific reason or goal shouldn't just be distributed just for the sake of it and just to the benefit of that entity that has the information at their disposal. That information, once given, must be secured, it must be stored in a professional manner, and it must not be distributed, it must be protected at all costs. Then a fun fact I put in here, because this is quite it's a jaw-dropping moment, is Poppy was actually assented to, which means it was accepted by the president in 2013 and only came into full effect a full 7 years later in July 2020. So a good question as to why it took 7 years for them to actually get it into effect. Only the good Lord would know. I do not. But it's a fun fact to know that we were sitting on a piece of legislation that was agreed upon and accepted for 7 years. Then another thing that we've heard many a times, FICA manual. So what is FICA? It's the Financial Intelligence Center Act. So you've definitely heard of FICA, and you probably think it only applies to banks and financial institutions. You are quite incorrect. The purpose of the act, and this is a summary, believe it or not, is to establish a financial intelligence center to combat money laundering, to impose certain duties on institutions and other persons who might be used for money laundering purposes, to provide for customer due diligence measures, to provide for a risk-based approach to client information identification and verification, to provide for the registration of accountable and reporting institutions, to provide the center and supervisory bodies with powers to conduct inspections, to regulate certain applications to court, to provide for administrative sanctions that may be imposed by the center and supervisory bodies. What does this all mean for my small business, though? Which is always the question. Um, like I said, it sounds like something that only has real consequences for a bank or for someone who loans money in the normal course. But in your small business, you are still required to obtain certain financial documents and to have the information ready and available should the FIC require same from you. So what should your manual contain? So just a sidebar there. A manual basically is something that's one, it's there for to show the authorities if they pitch up there that you have one in place. But more so, it's there for your staff to know what to do in certain circumstances. Um, we all work with staff of varying denominations. Some have a formal university degree, some literally came from high school. So you can't expect everyone to just know the law. Um, Even in an institution as ours, where it's a legal firm, we can't expect everyone in the firm to know the law. Naturally, there are several different employees in the firm, most of which don't actually have a law degree, but we still have to comply with the law at all times. So what should the manual contain? It should have guidelines and steps that the corporation is obliged to follow in terms of the act. It has to have directions regarding information and documents to be obtained and stored in respect of clients. And such information will usually consist of the client-specific information such as the ID numbers, the documents, proof of address, CIPC certificates, etc. Just also a sidebar fun fact is if you receive over a certain amount of cash in transactions, and I think it's an annual amount of just under 25,000 Rand, those cash transactions actually have to be reported to the FIC. In order to report these, you'll need all of these documents. So these documents are not there just for the sake of filling your cabinets. These documents are there for a very specific reason. If your client goes to the bank, makes a cash payment into your account, and that pushes you over the threshold, you'll be required to go and actually submit the information and to report that transaction to the FIC. So best be sure to make sure that all of these things are in place and that you've got everything in order. And on that note, also, just so everyone understands what exactly the consequences could be if one doesn't comply, it was in the news a few days ago that Nedbank has been slapped with a fine of 35 million Rand for non-compliance, and the majority of which was the information and the documents not having been obtained and stored in a sufficient manner, and then also cash transactions not having been reported. So one can imagine with an institution as large as Nedbank that they deal with billions in cash transactions. which automatically pushes them over the threshold. So if those are not reported, you can look at very, very big and dire consequences. So at our level and at a smaller business level, best be sure to make sure that you are compliant so that we don't deal with fines, because I think a 35 million rand fine is something that one doesn't laugh at when it happens to you. Then top tip, make sure that requirements are placed in your that are placed on your industry or business or put into and measures are put into place so that you can comply. Obviously that will be in your manual. So you have to go and make sure what the requirements are. Like I said, it's the set of requirements will differ from business to business. It's your job to make sure what are those requirements and to make sure that those are put into place as to avoid any consequences. Then another one, which I don't think a lot of people have heard of, but which is also quite prominent, is the PIA manual. So PIA means the Protection of Access to Information Act. So this sounds like it contradicts the POPI Act. It doesn't though, because the two have to work hand in hand. So certain information obviously is of the nature that it has to be available to the public. You can also not run it as if you're working in the Russian military. We have to also give some information, and some information has to be kept sacred. So the PIA Act actually tells us which information should be available and made available to the public. So the PIA manual also, make sure it's in writing, make sure it's available at your premises for inspection should anyone pitch up to inspect. The purpose of the PIA manual is to promote the right of access to information, to foster a culture of transparency and accountability by giving the right to information which is required for the exercise or protection of any rights, and to actively promote a society in which the people of South Africa have effective access to information to enable them to exercise and protect their rights, and to promote the effective government of private bodies as it is necessary to ensure that everyone is empowered and educated to understand their rights in relation to public and private bodies. So this is literally the purpose of the Act as it is taken from the Act, just put in a little bit more plain terms and a little bit more truncated. So Section 9 of the of PIR recognizes that the right of access to information cannot be unlimited, like I said, POPI, and should be subject to justifiable limitations, including but not limited to limitations aimed at the reasonable protection of privacy, commercial confidentiality, effective, efficient, and good governance. So naturally, when certain information should be protected by POPI, your PIR manual should recognize this. Your trade secrets are not something that has to be available for inspection, obviously. Otherwise, how can your business survive? And then the very broad term of effective, efficient, and good governance is as broad as one can understand it to be. And all of those have to be done in a manner which balances the rights with any other rights, including such rights contained in the Bill of Rights in the Constitution. Okay, that brings us to the close of the internal agreements portion. Like I said, those are some internal agreements. When one really has a sit down and thinks about it, there are some that we've actually missed, such as a director's agreement, etc. They really, the sky is the limit. And to really go into each and every agreement that could and possibly should be in place would take us days, not just hours. So perhaps we'll do a follow up on this webinar and go through some more or some specific agreements, whichever the interest strikes. Okay, so in terms of external agreements, so an external agreement naturally refers to an agreement between the company and some other entity, an outside entity, not something that's only applicable to the inside of the company, between the company and its employees, etc. So the first external agreement is the service agreement. So a service agreement is the agreement that we use. All of us either render a service or we promote or we sell a product. So this agreement is the one that's going to regulate that relationship with you and your clients. So it's the agreement that regulates the relationship between the company and its clients. So this agreement is usually drafted by the company, and naturally the terms will usually aim to protect the company's rights. Your service agreement should be written. This is to save your own bacon. It's not something that's required by law. It must be drafted using professional assistance. Again, this is to save your own bacon. It's not required by law. And it has to be in line with your business requirements. What I've put in here, and this is, I didn't put this in here just for the sake of fun. I've seen this a million times. A Google contract will not serve to protect your interest as they're generic and they don't serve the specific purposes of the company. So I've many a times Googled agreements. I've many a times seen what these agreements contain. And really you have to know the law and understand the law and be well versed in contract drafting to understand why these agreements will not serve to protect your interest. 99% of the agreements that one finds on Google is American, first and foremost. And in the second place, to really see if this agreement would suit your purposes, you actually need to understand the contract, which usually one doesn't if you're not trying to understand the contract or you haven't had the necessary tuition to understand the contract. So just dragging one from Google and using it and hoping for the best usually doesn't end up in the best. It's still better than no contract, but it's definitely not something that we'd give you or something that we'd at all recommend. So what should this contract contain, your service contract? So possible contractual terms are infinite, but the most relevant terms that must be included are the details of the contracting party. So that's the details of your company and of your client, the description of the service or that you render or the goods that you're selling, pricing, the pricing can be in very broad terms. Usually one has an agreement that stays the same for 10, 12, 15 years, and the annexure to it will have the pricing on it that just changes from time to time. And then usually we'll make sure there's a clause in your agreement that says that the pricing is dependent on, it goes up every so often, or the schedule literally will be varied from time to time, or there won't be a schedule annexed at all. It'll be as per the rates that are applicable at that time, which is let's say available on the internet or whatever the case may be. And then payment terms, quite important. And what I mean by payment terms is once you render your invoice, when is it due? Is it due on presentation? Is it due within 30 days? Is it due within 60 days? All of these things have to be determined by your agreement. Then any guarantees or warranties that you provide to your clients, and what the consequences are of breach of the agreement. So a breach of the agreement obviously is when either one of the parties don't comply with the requirements in the agreement. And if I can just circle back to warranties and guarantees, and this is where it gets intricate. Certain legislation also gives your consumer certain rights. So most notably of these is the Consumer Protection Act. So guarantees and warranties are covered to a rather large extent by the Consumer Protection Act. So what is important in terms of your contract is your your warranties and guarantees given, or any sort of anything that's actually covered by the Consumer Protection Act, cannot be less or less beneficial to your consumer rather than what the Consumer Protection Act allows. So if the Consumer Protection Act allows, for example, once you've serviced the vehicle, for example, the Consumer Protection Act allows you 6 months after the period of service as a guarantee period. If your car breaks down again in 6 months, it's the same thing. Obviously didn't fix it. Then, in terms of the CPA, you're allowed to go and you can claim out that warranty. So those rights in terms of the CPA, you cannot out-contract them. So if something is allowed in terms of the CPA, you have to allow it in terms of your agreement. You don't have to specifically mention it in the agreement. It's not going to really make a difference because the CPA will apply in any event. It is, however, a good idea to make sure that your agreement is compliant with those basic rights provided for in the CPA and any other legislation that you identify, to make sure that, one, you have an idea what's going on, you have an idea of what sorts of warranties obviously you're given, and then obviously also you don't want to be found to be non-compliant in any way or form. Okay, top tip that I've given here, and this one I've found in industry to be very relevant. It's way, way cheaper if you bring me your existing contract and you tell me what issues you have with the existing contract for me to amend the agreement to make it in accordance with your business requirements than it is to draft one from scratch. The reason for that is, like I said, yes, certain terms are standard in an agreement. Certain terms will always be applicable. Great stuff. But then the specific terms are usually when what takes a little bit more time and usually a little bit more up and down between the client and the attorney. So obviously, if the agreement is given, which has the specific terms in already that's been applicable up until that point in time, that saves a lot of upping and downing and drafting. And then also when one comes with this, these are the issues that are found, these are the things that don't work in terms of the agreement, then obviously we know exactly what to amend, and there's no trial and error phase after the amendment. You know exactly that your agreement is now in a manner, drafted in a manner as to comply with your business requirements. Okay, then the second agreement between your company and external participants is the supplier agreement. So what is a supplier agreement? These agreements regulate the relationship between your company and its suppliers or contractors. So in this instance, you are the client. So let's say, for example, you rent a printer on a month-to-month basis. Obviously, on requiring the printer and signing the agreement that you sign is not something that your offices have drafted or that comes from your office. It comes from the external company. So the agreements will be presented to your company for signature, and the supplier won't ask you for your input or invite your comments to it. This is a given. This circles back to the first agreement where it's your client's agreement. Is obviously it's drafted in a manner as to protect your rights. So naturally, the supplier agreement will be drafted in a manner as to protect your supplier's rights. I mean, this is a given. It is, however, your prerogative and your full, complete right to negotiate the terms of the agreement, and if you're not in any way bound to sign it as it is. So the very basic or the very basis of contracts is that we have contractual freedom in South Africa, which means that you are free for the most part to draft your agreements and to agree to whatever you feel that suits your needs, obviously with the exclusion of anything that is illegal, please. But I mean, an agreement presented to you was drafted by that company, like I said, for their benefit, just as you would do the same. If that agreement, however, contains something that's completely unacceptable to you and your business requirements, it's your job to say that. It's your job to say, I don't agree with this term. I'd like to amend it. I'd like to make the period longer, shorter. I'd like to change this, take this out, put this in. That's your prerogative. And like I said, it's your responsibility in actual fact. At the time of perusal of the agreement, note your dissatisfaction with any of the terms therein that is not acceptable to you or your business requirements. Because once the agreement is signed, it is accepted as it is, as one sees it. You can't go back then and say, no, but this term, I didn't see it, I didn't agree to it, I didn't like what it said in the beginning. It's too late. You've agreed to the entire agreement, you signed the thing. All of the terms in there are accepted to be agreed upon. Naturally, there are exclusions. Let's say, for example, they frauded your signature and that the signature that they are presenting on the agreement is not yours at all. Obviously, then the entire agreement is in dispute. But if you sign the agreement, you're willing to accept the agreement, then all of the terms in there, one, it's accepted that you've read them, you've understood them, and two, it is accepted that you accepted those terms of agreement to regulate the agreement between yourself and your contractor. Then another fun agreement is a joint venture. So probably heard of it, probably don't have a clue what it is, but let's talk about it. So a joint venture or JV is a type of business arrangement where two or more parties make an agreement to pool their resources to achieve a common specific goal. The goal can be a task, a project, any form of business activity, and all participants of the joint venture are responsible for all of the costs, profits, and losses associated with it. The relationship can be likened to a partnership, but notably, it's not a partnership. Example of a JV is where one party supplies the hardware and another party supplies the installation of that hardware. In other words, the labor. Um, a JV, just to give you a better, more layman's term idea of what it is, literally is two companies working together to do a specific project because the one company wouldn't have been able to do it on their own. And then obviously, in terms of that project, if there are profits, you have to decide how the profits will be divvied. It doesn't matter, it doesn't have to be half-half. It can be literally, I only bring the goods, so you do the labor, so you do the most of the work. So it's a 20/80, it doesn't matter. But it has to deal with the profits and the losses, and it's for a goal or for a project that you wouldn't have been able to do on your own. So then you literally go and you work with another company who's got the resources so that you can complete that project. There are certain minimum requirements for a JV to be classified as such. The most common type of joint venture in South Africa is incorporated entity. So most of the time they'll actually go and create a new company um, for the JV. So in other words, company A and company B work together and they form a new company which is called company AB, and that company is the one that signs the agreement with the contractor for the JV or with the client for the JV. So the joint venture as such is then a company and not the two companies working together. It's one company, it renders the service, but the two companies obviously work together in order to form and to operate that one company. Joint ventures are not specifically regulated in South Africa and can take a variety of forms. In other words, there's no legislation that says it has to be a company, it has to be a membership, it has to be this or that or the other. Obviously, that's up to the parties to decide. Essentially, you can either work as a team or register a new joint venture entity or company, of which the parties to a joint venture are shareholders. The agreement should, in every detail, set out what the relationship entails. Again, this is not a requirement by law, this is a requirement to save your bacon because verbal agreements never hold up. So it would say things like what share of the profits, what share of the work is attributed to each member of the JV, bank account details, incorporation agreements, etc. So normally a JV will also open a separate bank account to which the amounts in terms of the contract is paid, so that obviously one company doesn't sit in charge of the other company and dictates what the finances of the JV does. Then top tip, I think I've covered this, but let's do it again. A JV should be a written agreement. In fact, top tip is every single agreement should be a written agreement. The nature of the relationship is complex, and a verbal agreement will not lead to successful enforcement of the agreement if it becomes necessary. Just to give you an idea how the law works, and the big thing that we fall short on most of the time is in terms of evidence and the law of evidence. If one goes to court based on a verbal agreement and you say to the court, okay, I had an agreement with person X, the agreement was XYZ. Okay, great. That's your plaintiff's case. That's my version. Then your defendant comes to court and say, yes, I agree. There was an agreement with person X or person Y, but the agreement was that XYZ. Now we're sitting with two mutually conflicting versions, and the court will not find in favor of the plaintiff because you haven't proven your case. You haven't shown the court on a balance of probabilities that this version that I'm presenting is in fact the correct version. Obviously, it goes a bit deeper than that. I mean, you bring your witnesses. There can be 5 witnesses on the side of the plaintiff and no witnesses on the side of the defendant, and your plaintiff will be able to prove its case. But why on earth would you want to bring 5 witnesses to prove a case and to prove it an agreement, whereas you could have brought a physical written document that both parties sign that says this is the case, this is the agreement between the parties. It's not open for interpretation, it's there on black and white. You're only asking the court to look at it and to find in favor of you. Way easier from in terms of an evidentiary point of view. Okay, next agreement, and we touched on this one a little bit earlier, is your service level agreement. So the agreement, a service level agreement, is an agreement between the company and a contractor. Examples of service level agreements is an agreement between the company and a recruitment agency, or its accounting services agreement. Most small companies, I think, just outsource accounting services. So if one does, obviously there will be an agreement to guide the relationship between the parties. The defining factor of a service level agreement is that the service is rendered to the company, usually on a monthly basis. The agreement sets out the scope of work to be done by the contractor and what the price is agreed upon. Like I said, a good example is like an accounting firm. As let's say I have a construction company, I don't want an in-house accountant. They're too expensive, for example, but obviously I've got some accounting needs. Then you'll appoint an accounting firm. You give them whatever they need to do monthly. That is regulated by the agreement or decided by the agreement. You pay them X amount per month, and there you have it. They're basically a contractor of the company. They've got the specific duties that they need to perform, and they do it on a specific price service level agreement. Okay, that brings us to our last external agreement. Again, like I said, the sky's the limit, honestly. In terms of agreements, there will always be a million others that one can think of. Um, this is just the most obvious ones that, quite frankly, popped up into my mind and which I thought needed some discussion. But there will definitely be other agreements that you either you encounter or you think that they should be in place. There's definitely more agreements. We just don't have 2 days to discuss this. So agreements in your small business, and the takeaways are my summary of what our discussion was. One, it's never ever a good idea to rely on verbal agreements, since neither party can prove without a shadow of a doubt that what the terms are when called to do so. It'll always be a he said, she said. It's always going to be a mutually conflicting version. That is just the manner, or that is just the nature of um, having an agreement in word only, or in verbal form only. Spending some money and time on a formally drafted agreement or documentation will always ensure savings when you have a dispute. So yes, there may not be a dispute, obviously. We know some instances everything just goes swimmingly. But when there is a dispute, your written agreement will save you costs. Absolutely. And in some instances, it's actually going to avoid disputes completely. If you have an agreement that says, listen, I have to pay on 30 days, and your other parties to the contract calls on you to make payments on the 30th day, there is no way of disputing that. You need to pay the money. It's most likely a cash flow issue. Make an arrangement, pay the money. Could completely avoid a dispute in terms of handing over and legal. Uh, Definitely always make sure it's in writing. Um, Obviously, that's the only real way to prove what has been agreed upon between the parties.